Right. So, good morning, everyone. A warm welcome to today's session where we all are here to hear from this brilliant panel about the legal landscape of Bangalore and Chennai. Myself, Madhura. Before we begin, let me just quickly introduce Indian Lawyers Association to all of us. ILA started a few years ago with the vision to provide platforms to the lawyers of the country for continuing their legal education, their professional development, providing networking and mentoring platforms. And we necessarily operate on the model of having local chapters throughout the country. So these chapters add local flavor to the operations of Indian Lawyers Association. If you see a city here where you belong to, please join it. Please let us know if you want to join it. We would be very glad to welcome all of you there. If your city is not listed here, please let us know otherwise also, and we'll be happy to start the chapter. So I'll hand it over to Mr. Navneet Chugh, who is the managing partner of Chugh LLP and president of ILA. He'll be moderating the session today. So over to you.
Thank you, Madhura. Thank you for doing such a great job with the Indian Lawyers Association. We started in January 2018 with a goal to have 100 chapters throughout India. And then we found a list of the top 400 cities in India with a population of over 1 lakh. So then we decided that we will want a long-term goal of setting up 400 chapters in India. So it's a journey that will not finish for many years, but important to be on this path. We're at 75 chapters now. And on our panel today, on our webinar today, we have the two of the most active ILA chapters with 2 new presidents, Sonal Basu from ILA Bangalore and Ganesh Chandru from ILA Chennai. And I tried my best to have these 2 wonderful presidents agree to call today's session a Bangalore versus Chennai debate, which cities' lawyers are smarter and better looking and better behaved people. But these guys are like, no, we have to be civil. We just became president. This is our first event. Let's do this properly and modestly. So in Indian modesty, I agreed. But now that the session has started, we will see what happens. So I'm going to ask each panelist to introduce themselves one by one, and then I'll ask them questions. But I always like starting with somebody who's wearing new clothes for the first time today. So we'll start with Bharat today. So Bharat, would you introduce yourself? And then I have a question of you.
Thanks. I'm Bharat. To some, I'm MS Bharat. To some who have not met me, I'm Miss Bharat or Miss Bharati. But I completed law in 2001 from Pune University. Started my practice in Delhi with a firm by name Anand & Anand. Was with them for 20 years. Rose up to be a senior partner and ran their Chennai-based South India office for about 13 years until last year when I set up my own firm, Kriya Law. And at the core of Kriya Law is intellectual property, but it's a general corporate firm. We are a team of about 12 with 8 lawyers and growing.
So Bharat, you were earlier at a large law firm for 20 years, and now you've set up KRIA Law on your own. And I loved going to the website and trying to figure out what KRIA stands for. So I won't give it away. Let people look for it themselves. But now you're sort of running a business in addition to practicing a profession. So can you share with us what new challenges, how has life changed, what advice to others who may wish to follow your path?
Yeah, of course. When I was part of a large law firm, last thing I would worry is when would I get my salary or monthly payouts or checks. And running my own law firm right now is I would be the last one to take it through. Right? So we have a team of 12 or 15 or 20. We should ensure that the service providers are paid first, and then comes professional, and then your committed expenses of rent and electricity, just like any other startup. Right? So it's quite a challenge. It's like running any other, fintech or tech company or any other business for that matter. That when you are a founder, CEO, or you come last. But the fun part is actually the journey of bringing in the culture, core values, core team together, and onboarding clients, servicing them, the full journey. That's been the fun part, actually. The secret I would tell everyone is ensure that you at least try this once in your life, so that you also enjoy what we are enjoying.
Good. So Bharat, while I have you, a lot of changes have happened in the courts because of the shortening of times. Can you tell us what big changes have happened because of the shortening of timelines in proceedings?
Absolutely. 2015, there was a time when we had commercial courts. I mean, we do have regular courts, regular original courts. There are many courts, most courts in India have original jurisdiction where you can file first. And then there are high courts where you can file only appeals. The Commercial Court Act was passed in 2015 and rolled out in different time zones or timelines in different high courts. Between Delhi, Bombay, Calcutta, Madras, Allahabad, where original jurisdiction is still there, Delhi was the first to roll it out. And in the Commercial Courts Act, about 26 or 27 subject matters have been included. And if at all you have a subject matter which is listed there, then you go through an amended CPC, which shortens the life of the entire proceeding, right from the way you file it, right from the way documents are admitted, denied, the way issues are framed, the ways you can seek adjournments. There are only limited number of adjournments you can take, and you can be penalized for unwanted adjournments. Trials are shortened. There is an option of actually a summary judgment, which is Order 13A under the in the CPC as per the amendment, where the courts can decide. Of course, one of the parties should apply for a summary judgment. Is if there is hopeless case either on part of the plaintiff or the defendant, you can shorten by asking the judge to look at the documents rather than going to trial, examination in chief, cross-examination. If the court feels that there is a hopeless case or either on part of the plaintiff or the defendant, he can just take out a summary judgment as though and decide the case one way or the other. So there are a plethora of this, amendments which have been done from the Commercial Courts Act into the CPC, but that's welcome change. There are trials from filing of the suit to final hearing, post-trial. You can finish it off. The record, I'm told, is about 6 months or 8 months, but on an average, it takes not more than 12 to 18 months. So earlier on, pre-commercial court litigations would take 6 years or 7 years. That's something new here. But where it gets stuck is the final hearing. The trial is done very fast, but the judges don't have time to hear the final hearing. So that's something we need to possibly work on, but that's more on procedure, not in statute.
Okay, that's wonderful. Bharat, we wish you all the best with your new practice. And ILA Chennai will wait for you to when you get some time, because we still want you to become president. So maybe 2023 or 24, as soon as Ganesh is ready to let go.
Absolutely.
And if you are willing to appoint, we always like to have a president-elect. So whenever you're ready, please let Ganesh know.
Absolutely. Would be a pleasure.
So good you said this in a public forum. So
Over
this
to
is
you,
recorded
Sonal.
as well.
Congratulations.
Yeah, thanks a ton, and it will be a pleasure and an honor. Thank you.
Okay, pleasure. Over to you, Sonal. Congratulations on becoming the president of Indian Lawyers Association, Bangalore, one of the most happening cities in the world. I'm pretty sure ILA Bangalore will be one of the best chapters in the country. So wanted to ask you, Sonal, can you paint the Bangalore legal landscape for us? It's the center of technology and innovation and entrepreneurship. What's going well for the legal community in Bangalore? What are you hoping for? What is bugging you the most?
Thank you, Navneet, and it's a pleasure to be part of the ILA fraternity, and I wish to contribute in my 1-year tenure. So a bit about Bangalore. As we all know, it is the Silicon Valley of India. I guess more startups are formed in Bangalore than San Francisco. And as per the Indian Economic Survey from 2019 to 2021, I believe 4,500 startups were formed. So it's a very dynamic environment. There's a lot of innovation happening. There's a lot of, a lot of investments are, happening, are being made in this state, right, in Karnataka at an overall level. So a lot for the legal fraternity to be done. And I think we do have extremely diverse legal fraternity. When I talk about legal fraternity, I'm referring to both in-house and external, law firm setup. So we do have a lot of subject matter experts. A lot of networking happens within the group, to brainstorm and to align to industry development. So which is a good thing. I guess what is expected from the law firms is, which I think I echoed earlier as well, is that you need to be more connected with your clients, because there's so much of innovation happening, especially in the tech space. And we know that laws are not abreast with the technological developments. So it's extremely important that you engage with your clients on a continuous basis. Even if you're working with your client for 1 or 2 engagements, that does not mean that you should just stop communicating with your clients, because there's so much to learn from an industry perspective, which only an in-house team can relate to you, right? So that is one. Secondly, it's also important to generally keep an eye in terms of what's happening at a global level. To take PDP as an example, right? We are still not there, and I'm sure there's a lot of traction, but it's going to take some time. But it's important to understand what's happening globally, because we do have a robust, from a privacy standpoint, GDPR framework in place, but of course we have an IT Act and the SPDI rules. It's always good to keep an eye in terms of what's happening in Spain, what's happening in France, what's happening in US, right? CCP and other developments. So that kind of gives an anchor in terms of decision making to a lot of global companies. So that's one thing which I wanted to highlight. It's also important to have continuous engagement within the fraternity, because I could be in telecom space, someone else could be in core IT space, right? Someone could be in media space. I think if we have a lot more conversations within our fraternity in terms of what are the challenges, what could be done, what are those gaps, what consultation papers are getting issued, how could we contribute to ensure that we have robust regulatory system, etc. I think that would also help. And there's a lot of conversions happening. IT companies are getting into gaming business, gaming companies are getting into some IT stuff, travel companies are getting into logistics business. So there's a lot of conversions happening within the industry, and I think that really should be noted by the lawyers, because we all need to start thinking out of the box. And if we don't communicate adequately, or if you do not brainstorm adequately, then I think as lawyers you'd kind of get lost, because regulatory framework is still evolving in multiple spaces, right? So from that standpoint as well, the partnership within the ecosystem is extremely important. And last but not the least, I believe that law firms are doing a fabulous job, and I am very proud of the legal fraternity in Bangalore. They are ahead of the curve. They're always engaging and ready to support. But I think what we could also do is, and I believe Navneet, you are driving that charter as part of the ILA forum, is to have constant communication amongst folks in different states, right? So that everybody is on the same page vis-a-vis, the dialogue that we want to have, be it with, from a external government of affairs standpoint, etc. So we do echo similar sentiments in terms of the developments that we want to drive in the legal and regulatory space, which would in turn help various industries at large. So that's my view, Navneet.
So Sonal, thank you so much. Since you're a general counsel of a big company, and when we have a general counsel on the panel, we can't resist asking this question. So we won't spare you either. You work with law firms and lawyers around the world. Can you share with us a few things you look for when you hire an outside counsel?
Yeah, so I definitely look at the subject matter expertise, especially in tech space. There's so much happening, right? We are having conversations on metaverse. So if I decide to engage a lawyer on a project to do with metaverse, is a lawyer abreast with the technological developments, right? It covers multiple nuances, the tech development, people related, privacy related, the way you deliver, right, to a client, etc., etc. So I think the domain expertise vis-a-vis technology is something that I look out for. The second thing that I look out for is the law firm playing a role as a true partner, right? And when I say that, I don't want the law firms to act as a consultant, but really collaborate. And I guess all the general counsels would echo this. I would really want them to truly collaborate and continuously engage, so they're prepared ahead of time, especially in industries such as ours, because there's so much happening and the laws are not there yet. And the third thing that I feel, which is extremely important and that's more relevant for us, is to continuously engage with law firms so that we also learn in the process from them, because they cater to various industries, right? They're constantly liaising with the stakeholders from a regulatory standpoint, seeking clarifications where the law is not clear. So I think that collaboration is equally important. But net, I'm very proud of legal fraternity in Bangalore, and I have some of you, Purnima being one of them, who is always there to support. So extremely happy, no complaints at all, and it's a very engaging fraternity. So Navneet, that's the thing from my side.
So Sonal, if you don't mind sharing a little bit about your life, where were you born and how did you become general counsel of Mindtree, and what happened in between?
All right, so I'm a first generation lawyer. My uncle, who's a doctor in London, wanted me to be a doctor. Hence I took science in 11th and 12th. I was born in Maharashtra. Now, my entire family is based in Mumbai and that side, London. But I never wanted to be a doctor, and my uncle stopped talking to me for like 2 years because I decided to become a lawyer. So yeah, I am an accidental lawyer, but I have no regrets. I have thoroughly enjoyed my journey in the legal space, and it's been a wonderful journey. And I think especially our industry, the tech industry, is so creative. It gives a lot of space to lawyers to be creative, right? And lawyers, are expected to be creative in many ways. So I think from that standpoint, it's been a wonderful journey.
Thank you so much, Sonal. Congratulations again, and we look forward to working with you and making ILA Bangalore a huge success. And we're so happy you're president. Thank you.
Thank you, Navneet.
Okay, over to the beautiful city of Chennai, and over to the president of Ilh Chennai, Ganesh Chandru. Ganesh, would you tell us about your life?
Yep. Thank you. Thank you, Navneet. Thank you so much for having me again. And it's excellent to be part of this ILA chapter, as you may call it. And thank you for letting Bharat know that he needs to take over the reins in a year or two, when we hope to have a good chapter here. And I hope to have the support of all the friends in Chennai to make it a success story. Yeah, with that, Bharat, Navneet, I was born in Madras, as it was then known. And I did my law degree from the Madras Law College, century-old Madras Law College, which was established in 1891. It's one of the oldest law colleges in India, like in Bombay and Calcutta as well. And after I finished, I started my practice at the Madras High Court. And even as a law student, because as you know, government law colleges, after 2 hours of lecture, it is just chilling out. You spend time in the canteen having a cup of chai and samosa. So after the first year, I thought if I end up doing this, I'll probably end up becoming an actor or doing something else. I mean, we are still actors acting in front of judges and arbitrators, but I decided to spend my time usefully, and I was a permanent intern in a senior counsel's chamber as a law student, and apart from the time that I had to go to the college. And it was a very interesting journey in the college as well, because mooting and debates was something we did. And my good friend Sanjay is here, who's also a very great debater. And I did quite a bit of that, and that propelled me into doing dispute resolution and litigation. So that was what I was interested in, and I was focusing on litigation. Then I moved to Singapore in 1998. I started in my career in 94 in Madras and moved to Singapore in 1998 to do a master's in the National University of Singapore. I was there for quite a number of years. I did my research in NUS. Then I was a foreign lawyer with some top law firms. Then I requalified as a English solicitor in Supreme Court of England and Wales. And I'm also called to the Singapore bar. I'm an advocate and solicitor of the Supreme Court of Singapore. And during my 16 plus years in Singapore, Navneet, I was also with the Singapore International Arbitration Center, leading the case management division. I was also propelling their India initiatives, and I decided at some point I need to come back to India. 2015, I moved to Delhi, and 2020, I came back to Chennai after 5 years in Delhi. And here I am, in 2022 as the president of ILA Chennai. And I hope, with this, I specialize in arbitration and commercial litigation. And I do hope, we kind of bring this ILA chapter, not just in Chennai, but cooperate with other, chapters. Like this is the first initiative with Bangalore. I'm sure we'll do that with all the chapters, including your chapter in the US as well. Thank you.
Sure. So when you get drunk, you happily say that Chennai lawyers are better than Bangalore lawyers, but non-drunk on Zoom for the world to hear, would you say that now?
This is the googly you have thrown, Navneet. See,
Okay.
let me answer you in the lighter vein as well. Perhaps Bangalore lawyers are a little better because many are originally from Chennai in Bangalore. That was just on the lighter vein, but I think both Bangalore lawyers and Chennai lawyers are excellent lawyers, Navneet. In fact, just going back to a little bit of, because Sonal was talking about Bangalore, so I can give you the landscape of Chennai and then also answer your question specifically, the legal landscape. See, as you know, as you are from India and you know how the modern legal system as such, I'm not talking about the Vedic times when we had excellent legal systems, or during the Mughal Empire where they had their own way of administration of justice. But when we talk about modern legal system, we talk about advent of the British, and we follow the common law today in India, like the US, Singapore, and many other common law countries. So in fact, Chennai, as Madras as it is called, was the Madras presidency for entire South India, and so was Bombay presidency and Calcutta presidency. These were the three main presidencies. And in Madras was the first place where any formal court was commenced. The modern court was commenced by the British. In 1687, the Mayor's Court was first established in Madras. And then again in 1726, there was another charter where they established a Mayor's Court in Madras, Bombay, and Calcutta. So if you look at the legal history, we go back, the modern legal history is quite far, we go back, 300, 400 years. And this was the first corporation, the Madras Corporation was the first corporation to have been established in India. And in fact, the second in the world after London. So once they established the corporation there, they followed suit and did it in Madras as well. So there was this Mayor's Court, then you had the Regulating Act, we had a Supreme Court at Calcutta, then you had Supreme Courts in Madras, Bombay, and Calcutta. And then the modern High Court, which we have today, we call it a Chartered High Court, the Madras High Court, was established by way of letters patent by Queen Victoria in 1861, as at the same time, around the same time in Madras, Bombay, and Calcutta. So if you talk about history, and in terms of the legacy for entire South India, it is the Madras Presidency and the Madras High Court, which is a starting point. And in terms of legal education as well, Madras Law College is a little younger than the Bombay Government Law College, but it's probably the second oldest in India. So I think that is the kind of legacy. And if you talk to anybody from, be it in Hyderabad or Andhra Pradesh or Karnataka, they will all have this close connection with Madras. But that said, coming back to the present, yes, it's now Tamil Nadu is a different state, Karnataka is a different state. We all have separate high courts. In fact, Madras High Court, Navneet, as you definitely know, has produced some stalwarts in terms of lawyering, like other places as well. We've had several judges of the Supreme Court from Madras. We've had at least one president of India, Mr. R. Venkatraman, who was from Madras Law College, and he practiced for a while. And we've had 3 attorney generals, Mr. K. Parasaran, Mr. G. Ramaswamy, and the current attorney general, Mr. K. K. Venugopal, also started his practice at the Madras High Court. So in terms of history and the contribution to the legal scene in India, Madras has definitely done a lot. Today, we have, in addition to the High Court, also the NCLAT.
Okay.
The Southern Bench is headquartered in Chennai. As you rightly put in your, we put in our flyer, it's home to manufacturing. It's called the Detroit of, Detroit of India. Probably one day, Detroit will be known as the Chennai of America, probably, if they're going to move everything here. So, and
Right.
we also have so much of...
I got your answer.
Yeah. So this has been basically, I wanted to just tell you indirectly that
Okay.
we are not greater than Bangalore. They are not greater than us. We are all equal. Yeah.
Okay. So Purnima, will you introduce yourself?
Hi, Navneet. Good morning, everybody, and good afternoon, just now that we're at 12:01. My name is Purnima Hatti, and I lead the dispute resolution team at Samvad Partners. I'm based in Bangalore. And I now have close to 2 decades of experience in the dispute resolution field. I graduated from the National Law School here in Bangalore, went on to read law at the LSE, and I have lived and worked in London, Singapore before coming back home to Bangalore. So it's lovely to be here and see the healthy conversation between Bangalore and Chennai. We have offices in Chennai, and Chennai is very much part of where I work as well. But as a true blue Bangalorean, I've grown up here. Thank you for having me on this panel, Navneet, and I look forward to the conversation.
Thank you, Purnima. Over to you, Sanjay. You're one of the most colorful people I've ever met in my life. Want to hear about your life.
Thank you, Navneet. I'd start with a caveat. Much as you'd like to pit Chennai versus Bangalore, I'd say I'm conflicted because I'm a product of a hybrid marriage. My mother is from Chennai and my father from Karnataka, so he's a Konkani Tulu speaking person. So I will steer clear of any direct confrontation with my counterparts from Bangalore. I actually made a transition, Navneet, from the newsroom to the courtroom. I graduated in law in '97 from the same college. I was Ganesh's junior at the law college and from the same debating circuit. In '97, the Bar Council of India had brought this compulsory apprenticeship route. So thanks to them, I look very young on a bakalat when it says 2012, but actually I graduated in '97 and joined NDTV in the summer of '98. It was with NDTV. I resigned as resident editor of NDTV 24/7 in 2012, and at that point I got enrolled with the Bar Council, and that's why that explains, the young streak to my vakalat, which is 2012. I'm also an arbitrator at the Madras High Court Arbitration Center. I write arguably what's the longest running legal column in the country called Justice for All in the Deccan Chronicle newspaper. I've clocked 280 so far. And I'm an author of 4 books, including 2 on law. I love public speaking. I was a national debating champion in my college innings. And this lateral entry comes with a lot of challenges because, as Bharat earlier said, you get I've been used to a paycheck at the end of every month. And now it's a question of putting your heart and soul into your work and just about trying to make enough to keep the 2 together.
Wonderful. So while I have you, Sanjay, I have a question for you. And the question is, live camera arguments, and does technology bolster open justice? What do you think?
Well, sitting in the comfort of my law chambers here in Chennai, to give you an example, I was able to log in and soak in the arguments in that hijab case recently in the Karnataka High Court. And that was thanks to live streaming that was relatively seamless. And I think for other high courts and the Supreme Court to follow suit, we need to address a few questions. And the first question is this principle of open access to justice merely about keeping the doors of our courts open to the public, or is it more than that? Now, if it's only keeping the doors of our courts open, then we know that in all court complexes, for security reasons, there are restrictions. And litigants have to queue up at designated counters with letters from their lawyers. Even, law students have to apply for monthly passes. Can you imagine medical students having to apply for monthly passes to enter into government hospitals? This will be tokenism. So if justice is to be done and also seen to be done, as we always hear, it's time that, Navneet, technology is used for live streaming of court proceedings. And I really wonder what's the impediment here, because the Supreme Court seems willing to go live, as it were. The center had mooted a TV channel along the lines of Rajya Sabha and Lok Sabha TV. And the apex court in that landmark Swapnil Tripathi versus Supreme Court in 2018 came to a progressive conclusion. And I quote from this judgment very briefly. I have 2.5 minutes, as you had mentioned earlier. That for lawyers and judges familiar with the cocoon of a physical courtroom, live streaming would require attitudinal changes. They include the maintenance of order and sequencing of oral arguments. Unquote, we've had very colorful instances where people appear shirtless, eating masala dosas, smoking a pipe, and much worse actually during live hearings. But the court noted, slow as we have been to adapt to the complexities of our age, it is nonetheless necessary for the judiciary to move apace with technology. By embracing technology, we will only promote a greater degree of confidence in the judicial process. Now, this open court system is not some favor that is being rolled out to us. It draws its legitimacy from 2 articles. Article 145(4) of the Constitution, which makes it clear that no judgment shall be delivered by the Supreme Court except in open court, and the right to freedom of speech and expression under Article 19(1)(a) of the Constitution. And that right should not just be available to the court beat reporters. That right should extend to the readers, to the litigants, and to the general public. And therefore, Navneet, I believe that open court cannot be interpreted to mean only concerned parties. Because when there is public interest involved, the scope for dissemination of court proceedings cannot be confined to media reports. Many years ago, Madras High Court, they beamed a contempt of court hearing live on a big screen, like, you would have the soccer matches and all that, live on a big screen in the court compound. And that was an experiment that suggested that, transparency is the way to go forward. The blessing in disguise of this pandemic has been that it has induced virtual hearings that seem to have been going on quite seamlessly, with, of course, bloopers, as is the case everywhere. Yes, there are issues where, it could be misused, but then they are few and far between. I believe that stakeholders cannot be restricted to parties in a case. We're going to say only litigants should be allowed to enter courts. That's not the case, because a champion of a cause may not be on record before the court. He may seek to implead in a case at some point. And look at the other places. For instance, if educational institutions can live stream their annual days or convocations, if companies can do the same for their annual general body meetings, why should courts fight shy? And I'm not suggesting, Navneet, I'm not being radical here, that cameras should be allowed inside the court. That could lead to possible chaos, because I come from that medium. I know how things can, people can go berserk. I'm not even suggesting that courts permit Facebook Live. Like, for instance, I think Supreme Court of Florida a few years ago once did. They allowed, Facebook Live proceedings. But I believe that the transparency that will inevitably follow is not just for the judges hearing the case, but also between lawyers and their clients. A client deserves to know how well his lawyer argued the case, whether an adjournment was sought, and why. Particularly in the context of Section 36 of the Bar Council rules, which prohibit advertising, live streaming will be a boon to junior lawyers whose performance in court can be showcased, can be viewed by their seniors and prospective clients. The downside is that people believe that lawyers, judges even may play to the gallery. I beg to differ. On the other hand, I feel that a camera tends to have a salutary effect on the conduct of people. Yes, there are exceptional cases, even in that landmark Mirajkar case, when it comes to marriage, divorce proceedings, when it comes to Section 51 of the CPC, 228A of the IPC, sexual offences, POXO cases, and all that. Those can be in camera. But I believe that the merits far outweigh the demerits when it comes to live streaming. And at the heart of this debate really is the pursuit of truth, and a camera never lies.
Thank you. Thank you so much, Sanjay. You're so right. In some countries where there are juries, then on a daily basis, for instance, in the more populated countries, 1 million people could be serving on a jury trial. And as bad as the jury system may seem, and what a waste of time, 12 people sitting there listening to who committed the murder, who stole the bread, was this employee fired illegally by the employer, and divorces, or okay, at least divorces, there's no jury trials. But every day, 1 million people go to court, wait for their jury number to come up, and then sit in the jury for a day or 2 or 4 or 5 or 10 or 20 or 3 months. But in the process, they learned so much about the legal system, how the courts operate, how do the lawyers operate, how there is justice in the country, how to become better human beings, because they see a criminal on the stand who's going to now spend 10 years in prison. And so it's like a civil instruction on judiciary and justice system on a daily basis. And your idea of all this should be allowed on television is in lieu of a jury system, it's wonderful. Thank you. So Purnima, I have a question for you. 36 million pending cases. The oldest case in India is still going on in Varanasi from 1878. Someone wrote a paper that it'll take 400 years to clear the backlog. You lead the dispute resolution practice at your firm. Any resolution solution do you have for the entire country's backlog?
Thank you, Navneet. I think that's a very important question, and it's also not a new question, right? I think all of us, from the time we've been interested in the law, even before we joined law school, have had the idea of such a huge backlog and the implications of such a backlog at the forefront of our conversations. And like Sanjay just said, access to justice is also connected to pendency. When Indian clients as well as international clients often ask us, how long is it going to take to enforce this award? Will I even be alive by the time we get what we want from the system? It's very difficult to even answer that question as lawyers, right? There is an appeal process. Indian courts are slow, lawyers can be expensive. So it's extremely unfortunate that that's where we are, and the pandemic hasn't really helped. While we did move in terms of technology, only very urgent cases were heard, and what constitutes urgency was a matter of discretion, and a lot of people had to step back. We even heard of many stories where young lawyers actually left the profession. I know that in the Bangalore Bar Association, bags of rice were given out because there were a lot of people who just didn't have any income at that period. So it just it just puts a sense of what kind of lawyers. It's a big country, a huge range of lawyers, wide range of clients, and access to justice remains elusive. So I'm not going to pretend that I have an answer to that question. It's going to be something that we have to grapple with. But I think there is an increasing shift in terms of legislative changes, and Bharat mentioned the commercial courts and tighter timelines. So we are seeing some progress there. We're also seeing an increased interest in the alternative dispute resolution space. There's a mediation bill that is pending right now before Parliament. A lot of us have been involved in discussions around that. Mediation has a success rate of above 80% all over the world. A lot of courts, including the commercial court, for instance, has mandatory mediation that could be waived in certain circumstances. But so we're seeing a shift. Now, what I'm hoping that with more alternative dispute resolution systems in place, people will still continue to approach the formal justice system. I also sit on the board of an organization called Daksh, which looks at issues of social justice and access to justice. And studies there show that Indians actually, a lot of times, and particularly disadvantaged communities or women, don't actually go to court, right? So you would go to your panchayat, you would go to the police, you'd go to the closest religious leader, whoever else to resolve your dispute. So you're sort of going outside the constitutional framework to resolve disputes. How do we ensure that people continue to approach the formal justice resolution system to make sure that they actually get justice and not some sort of, like the Khap Panchayat handing out a view on what is right or wrong. So then this has to be more robust and more accessible. So I think as all of us are stakeholders in that, and we must continue to work to ensure that that the right talent comes in. We of course need more judges, we need more courts, and I think we should use technology more to resolve disputes. So I think if we see a number of startups in the online dispute resolution space, which has cropped up in the pandemic. Small disputes arbitrated over a period of a few hours even, and if that's accepted and enforced, that reduces the burden on the courts. So I think,
Purnima, I keep wondering, and it actually bugs me that
yes,
all these Indians and Indian companies keep going to Hong Kong, Singapore, London for arbitration. And we are one of the oldest civilizations in the world. And we can't handle our own arbitrations and mediation, and we're losing all this revenue to foreign countries. Why can't we do this in India?
absolutely, I think Navneet, and I think Ganesh and I have known each other since our Singapore days. It's the kind of talent that exists in India. Our lawyers are second to none, right? And if you go to Singapore or Hong Kong, and I sit as an arbitrator, so we see enough people who are of Indian origin or India qualified sitting. So there's no reason that we should be sending our cases to be resolved elsewhere when we do have the ability to do so. I think there are institutions now like the MCIA, where we've got homegrown institutions which are showing great promise. We have a new institution in Hyderabad. So I hope that shift will mean that we will continue to arbitrate and resolve disputes here. But of course, enforcement is a challenge. The moment we have to go to courts to enforce, and then we're part of the larger system. And then if somebody doesn't want to enforce or challenges the enforcement, we hit a roadblock.
Thank you so much, Purnima. Yeah, I'm sure India is capable of doing it. It's just a matter of time. Well, I guess there needs to be a little more trust in the process, and that'll happen. On a personal note, I'm glad COVID is kind of ending, and we're finally saying goodbye to it. While we say goodbye to it, I want to hear from at least one of you about how did you handle the COVID-19 fallout mentally and physically, and at home and at work. Ganesh, what did you do?
It was completely unexpected, as you would appreciate. Nobody anticipated that something like this we'll ever face in our lives. But thanks to technology, I think we all survived in our respective kind of commercial roles as we are playing at work. For example, at our firm, Dua Associates, I think we gave a complete freedom to the lawyers to choose if they want to completely work from home as long as they had technology. That way, I think it was a boon for people who are with law firms. But as Purnima said, I guess independent lawyers had a great it was not easy, especially those who had to go to court every day, especially the subordinate courts, to pick up work on a daily basis. So I think there was a kind of disparity again there, Navneet, like any other aspect of life in India, where lawyers were better off and were with good firms or had reserves survived this this aftermath of the pandemic. But that said, I think one thing which we thought that the courts in India, right from the Supreme Court to the lowest court, could use technology was something we never imagined. So it was a doctrine of necessity. So they had to implement this. And now, though we may say, you know, the platforms are not safe or secure, but we managed, and I think we managed it quite well. And the Supreme Court stepped in and gave an order for limitations to be stayed so that justice is given to the parties at the end of the day. That was at work. At home, I think it was fantastic to be at home because as lawyers, you know, I mean, we are hardly at home except in the evenings or the weekends sometimes, and as litigators when we have a trial or a arbitration hearing, and that's it, you know. Where so I guess this was a kind of a eye-opener to, though be at home, we are working, you know, when we are at lunch, we meet the family, at dinner, we are again together. So that way, I see a positive point there to see the kids doing online schooling and now realizing that, oh my God, I can't understand this mathematics problem. Good, I became a lawyer. So things like that, Navneet, that's how we manage, both positive and negatives, yes.
Wonderful. So along the way today, we lost one panelist, Pramod, but lawyers always have solutions. So we're gonna add a new panelist to our panel. He's Dr. Shafiq Shahul Hamid. He just became president of ILA Kollam 3-4 days ago. And the good thing is that he so far doesn't know he's on the panel, so he just found out. So thank you, Dr. Hamid, for joining. I guess you made a mistake of joining, so here you are on the panel. And I'm very proud of you, Dr. Hamid, and your life. You're founder chairman of the National Human Rights and Humanitarian Federation and doing an absolutely phenomenal job. And I have a lot of friends that do humanitarian work around the world. And their number one complaint is that lawyers don't help them and help the community and country as much as lawyers should do. Do you have a similar complaint, Dr. Hamid? And could you tell us how we could, lawyers in India can help your organization and other organizations preserve human rights of citizens of India? Dr. Hamid. You'll have to unmute yourself. Okay, so while we're waiting for Dr. Hamid, I have a question of Sanjay. So Sanjay, you're a lawyer, a journalist, an author, a TV personality. How do you reconcile the fact that lawyers in India cannot even advertise in a newspaper or TV or radio or the internet? Do you think these restrictions will ever be lifted in India? And do you think it's time that they be lifted as soon as this year? And what do we have to do about it? How do we get them relaxed?
You know, there was a time when lawyers would accept fees, good old days. They would accept fees. They had those pouches in their gowns and fees would be deposited in those pouches. We've evolved. I think the time has come for us to stop demonizing advertising. Advertising is not an illegal activity, in my opinion. Advertising does not in any way denigrate the noble profession of law, the only profession that finds a mention in the Constitution of India. I think a lawyer is a salesperson of ideas. A lawyer takes up a wakalat, holds a brief for a client. So why shouldn't an advocate talk about himself? Why shouldn't an advocate publicize his or her credentials? That beats me. And you know, at the end of the day, it's about choice. It's a question of serving the client. The client is entitled to know what lawyer, what's the specialization of that particular lawyer. Today, we don't land up in an orthopedician's clinic for a tooth extraction. Similarly, there are so many clients who don't know whether this lawyer specializes in arbitration whether he handles criminal appellate work, whether he's only a civil side lawyer, whether he does IPR work. So I think in the interest of the litigant public, it's important that lawyers are, I think the Bar Council rules in many ways are archaic and haven't lived up to the times. They have to be, I think there's an urgent need to overhaul the Bar Council rules, the Advocates Act as well. Having said that, I must say that lawyers are also very good in surrogate advertising. If you look at most law firms, the signature in the mail will have best, a judge best of this, or top 50 law firms. You have, where strategically you stop. Okay, I thought that someone's playing censor here because I was saying things which are not probably a little controversial.
No, sorry, it's my mistake. Sorry.
No problem. No, I thought it was strategic. No, so I was telling you that, we have webinars where we talk about issues that we specialize in, nothing wrong. We talk about our credentials, we have websites of law firms where there is a button which says, I understand that this is not for solicitation, this is only for information. So somehow word gets out. This is perhaps surrogate advertising. Why can't we open it up? And let's regulate advertising. Let's not have, advertisements on billboards that say divorce in 24 hours. Committed a crime, we'll get you out. I mean, that's over the top. You can regulate that. But I think the time has come for us to be able to, because now the only advertisement I know of lawyers, when they put out their public notices, you have the name in the newspapers. Okay. So, there was this serial on TV called Better Call Saul. Right. So why can't we have Better Call Ganesh and Better Call Purnima and Better Call Sanjay when you have certain issues that we specialize in, where we'll be able to do justice to the client? This is a proposition. In fact, I raised this issue with a friend from the Bar Council of India, whom I had featured recently in an article. And he said, look, it will only add to the inequality in the profession, meaning that, those who can advertise, who have deep pockets, will be able to then steal a march over those who are not. But inequality is a fact of life. Inequality exists. Are we going to run away from the fact of inequality in our society? Even today, even during the pandemic, Ganesh was mentioning, yes, during the pandemic, there were lawyers sitting in the senior counsel, sitting in the Supreme Court, appearing before the Madras High Court. Weren't they then depriving lawyers of briefs here? So inequality will always exist. To say that advertising will only fuel inequality, in my opinion, doesn't really hold water. So I think we must revisit the rules of our profession, permit advertising, not over the top advertising, but regulate it in such a way that we can get the word out. We can serve clients. Clients will be better informed on, in terms of choosing their lawyer. And I think it's a win-win for everyone.
Right. Including the economy when lawyers spend money
Yes,
on advertisement.
Absolutely.
And isn't it restraint of trade? According to Article 19, I believe it says that.
Reasonable restrictions, 19(1)(g), there are reasonable restrictions, and these are statutory restrictions imposed by the Advocates Act and Bar Council Group. So, that's how they've been able to get away. For instance, now, the Bar Council of India had a 1-year compulsory apprenticeship rule in 1997, later struck down by the Supreme Court. Thanks to that, I could not get enrolled in 97. I lost 15 years of my seniority. I was talking about looking very young on a vakalat. I would have been enrolled in 97. And when I joined NDTV in 98 and got back to practice into the profession, played prodigal son in a sense, in 2012, I would have just had to suspend my practice and then resume my practice with that original 97 enrollment number. That still hurts me. Why is that? We are so why is it we have these restrictions? And also then the Bar Council is trying to impose an age cap on, enrolling. In the US, that I think in New York last year, a 75-year-old lady got enrolled as a lawyer. There's no limit to learning. Yes, there are cases where they say that those who work in income tax, sales tax department, strategically 3 years before their retirement, they'll study law. They'll go to some evening, some college where they don't have to attend classes. There are malpractices there. But I think we need to open up the profession. What are we scared of? Law is an ocean, really. I don't think there's need for anyone to be insecure. Law is an ocean.
Right. Thank you so much. Purnima, I told you I won't ask you this question, but I'm going to ask you anyways. They say that any country that does not allow contingency lawyering is basically saying there is no justice for poor in this country. Do you agree? Do you think it's time we allowed success fee or contingency lawyering in India so that the poor of India can finally afford a lawyer?
Thanks, Navneet. I just wanted to also say, I think Mr. Shafiq is online perhaps, and he said hello in the chat. So if you want to bring him in.
Yeah, he told me that he's not feeling well. He's very happy that he was made an honored panelist, but he says he can't talk. So next time.
Sure. All right. Thank you. Thank you for the question. I think there's not enough debate on contingency lawyering in India still, for whatever reason. And the queries that we get on contingency fee arrangements are often from overseas lawyers, particularly from US clients and others. And it's an interesting perspective to see that is also an access to justice issue. I think there's not enough debate because we feel that the court systems are not always predictable in India. And it goes back to the conversation that Sanjay was talking about just now in terms of Bar Council changing its views on many things, right? So why not? If somebody is happy to accept a contingency fee arrangement, what then is preventing, as far as the full disclosure with the client and the client understand what is happening, I don't see a problem with that. And again, like surrogate advertising, there are many lawyers who do work, let's say in land acquisition matters, where the very poor land is acquired, and it's an unsaid rule, but they get the lawyer takes a percentage of the fees when the compensation comes in. It's delayed payment, the government will pay, and sometimes they will file an appeal just so that, let's say the Supreme Court will increase the compensation. So there is definitely a short compensation in the case of land acquisition, and we've seen this play out despite Bar Council regulations. So personally, I don't think there's anything wrong, and I think that from an access to justice perspective, it's an important idea to play out. We must ensure that there's no abuse, therefore, and that's something that we have to safeguard against. But just because there is a possibility of abuse, one shouldn't hesitate to engage with new reform. And I truly think that we need a lot of changes and a hard look at our Bar Council rules and regulations, and perhaps even the Advocates Act.
Isn't it true that 600,000 of the 1.3 million lawyers in the country have fake law degrees? What's bigger abuse than that? If any abuse we should be fighting, it's that, not success fee lawyering.
True.
Right?
Yeah, absolutely. And it's unfortunate.
So
I just can't understand how there are so many fake law degrees. It's just truly unbelievable.
Right. Including judges with fake law degrees, I'm told. I was in Chennai in November 2017, and I opened the newspaper, Times of India front page, fake magistrate serves as judge for 21 years. And his lawyer said, wait a minute, this is not fair. This guy has been a judge for 21 years now. Are you saying he's not a lawyer? That was his defense. Okay, so an incredible thank you to all of you. We're not done yet, but I want to thank Ganesh and Sonal and Bharat and Purnima and Sanjay for participating today. An absolutely wonderful conversation. You guys are just awesome. I was hoping to declare a winner of who has better lawyers, Chennai or Bangalore, but I'm impressed equally. Now we will move on to our audience question and answer session. And at this point, since it's an ILA, Chennai, ILA, Bangalore event, and Purnima, would love to have you be president of ILA Bangalore after Sonal. You're just incredible. Please consider. So we then let the ILA presidents handle the question and answer session. So all yours, Ganesh, today.
Yeah, I think Sonal has just left for some meeting. Are there any questions from the audience? Madhura, could they ask the question or should they put it in the chat? What is their procedure?
Actually, there's nothing in the chat so far, but I'm sure the audience will be having some thoughts to share or to ask all of you. So I request our participants, if there is anything, you may please unmute yourself, or you may also put it on the chat to either me directly or in the open forum. No.
Anyone having any thoughts generally?
In the meanwhile, I have one question, Ganesh.
Yeah.
This is for Purnima. The
Yes.
question is, according to LinkedIn, you're hiring for associates in your firm. What characteristics, what attributes, what skills must a lawyer present or possess to be a good lawyer so that you would hire them?
Thank you, Navneet. Yes, we are hiring. So if anybody's interested, please do write in. I think there's, like with most other parts of the industry, there's a crunch of good lawyers, at least in Bangalore. I think the pandemic has taught us that, other than hard work, we also need committed lawyers. It's also important for us to have lawyers with resilience, and committed to the workplace. I think that's important. As Sonal also highlighted some interesting factors about being able to connect to the client, and engage with the client continuously. I personally also look for lawyers who look beyond the law. It's sometimes you just know the statute and how judgments and precedents are written, but we then work in silos. Only when you know beyond the law that you're actually be able to make a difference to the society. And we must understand that we're part of a larger framework, not just a cog in the wheel somewhere. So I think those are the attributes that I would look for. So please do keep that in mind if anybody's applying. Thank you.
Mr. Iqbal, would you want to ask a question?
Yeah.
Hi, this is Iqbal from Dua Associates. Thank you for this thoughtful discourse this morning, and it was a real joy hearing all of you. I have a question for my colleague, Chandra Ganesh. How do you see the new mediation bill impacting the litigation landscape in India?
Yeah, thank you. Thank you, Iqbal. I think the new mediation bill is, as I think Purnima had said, is has been kind of is still in its nascent stage. It was introduced in the Rajya Sabha and has been sent to a parliamentary standing committee for discussion. So they already invited the stakeholders to give their views. It is a little different from the draft mediation bill that was circulated earlier for comments from the public. For example, India has signed the Singapore Convention on Mediation a few years ago, Iqbal, in 2020. And we were hoping that we will ratify that. We need to wait and see whether that will happen. That's on the international settlement agreements as such. But insofar as India is concerned, your specific question, how is it going to impact the market? Mediation is already there in India in several forms and several legislation. For example, we have the Arbitration Conciliation Act, and the conciliation part deals with typically what it is with mediation, though the term used is conciliation. The mediation bill now aims to kind of bring an enactment saying that part of the Arbitration Act, what refers to conciliation, will be now known as mediation. So this has already been in vogue, and I don't think there's going to be a difference between the terminologies conciliation and mediation in India. That's a great change, first of all. Next, there are several legislations in India where mediation is, where parties need to attempt mediation. So I think the Act also takes care of that, and it also makes sure it doesn't apply to certain industries and certain sectors. So I think it's an all-encompassing mediation bill, but definitely there are certain teething issues with it, which I'm sure many of them have written down. In fact, we had some discussions. There are institutions which are looking at it, and hopefully we get the law right, because like with the 2015 amendments, when we did it, one major loophole there was whether it was prospective or retrospective, and there were several rounds of litigation in court. I think this time we should avoid that, and hopefully it will definitely have an impact, hopefully, because now they're saying you need to have compulsory mediation. If that happens, I think it'll change the landscape and hopefully reduce the court docket explosion in India and the litigation sphere.
Okay, sure. Thank you.
Thank you, Iqbal. Anybody else has any thoughts?
Thank you, Ganesh. Yes. So, Ms. Vidya Pinto in the chat has a question. Copies in the case were destroyed by termites. Isn't it time to go paperless? Anyone of the panelists?
Can maybe Purnima or Sanjay, do you want to take that?
Yeah, I mean, Purnima, can I take it?
Unless you're
Considering
conflicted out,
Not conflicted. we are on the same
You
side.
get to go for that.
Vidya is my wife, who also had a lateral entry like me. She was a
Yeah.
professor turned lawyer.
Yeah.
I'd like to hear what Purnima also feels about this, though. I for one believe that the process of filing in our courts is a human rights violation, and I'm not exaggerating. The way they nitpick, the sure, the torture that one goes through in putting together all these things. Of course, now they've migrated from legal size green to pretty much a uniform system across the country to A4 size white and all that. The way these people in the registry very innovatively come up with objections can be mind-boggling. So I think we need to simplify it, and that's why I'd like to hear what Purnima has to say, because I'm just wondering, I was just thinking aloud at home just recently, that if you have an online dispute resolution system, given the overall disenchantment with regular litigation in courts and with the docket explosion, if we can devise a system. The other day I was also listening to a talk by Richard Susskind, a well-known mediator, international mediator, who said that online dispute resolution centers can be like you have a blue tick mark on Twitter for a verified handle. You can have accredited online dispute resolution centers accredited by different high courts in our country, where you can have a simple form. Like, for instance, if you look at arbitration, the Arbitration Act very clearly says you don't have to go by the principle, by Civil Procedure Code, or by principle, or by the law of evidence. Ditto with the Consumer Protection Act. So if you can have a simple form, and if you can, sort of cut through the clutter, as it were, where you just fill out a form that can be preloaded and fill in your details with a minimum number of characters or words or whatever, and let those be the pleadings. When you have statutes that specifically allow you to dispense with and steer clear of cumbersome civil procedure and evidence laws, why aren't we making use of that? So I think online filing is the way forward, really. There will be teething problems. I, in fact, wonder why we even have to stick the other day, after what I thought was a flawless filing exercise, because I'm by nature a little meticulous. The section return of Vakalat Singh, this 1 rupee stamp is missing. So why can't we have, for instance, a wallet, an e-wallet in our courts, where lawyers, you don't have to bother about fixing stamps or about, going into the stock holding corporation and uploading stuff, creating a printout of that and putting a printout itself is a huge challenge there. So why can't we have a proper, simple online system where anyone can file? Like the way when they advertised when the Consumer Protection Act came into being in 1986, that, the Jago Ray campaign. You have a bill, you attach a bill, you file it, and that's it. The most cumbersome filing thing is in the Consumer Protection Act. You have a statutory timeline of 3 months, where a single adjournment of the National Commission is 9 months to 1 year. And cases of 2011, I'm still fighting. Okay, so I for one believe, I agree with Vidya. I think the time has come, induced by termites in this case, for us to have an online filing system, maybe as a hybrid system, make it optional, and gradually move into that. I think that's what even Justice Chandrachud and others seem to be in favor of. Purnima, I'd like, because you're the expert really in ODR, I would like to know from you whether this is something that's feasible in the short term.
No, I think it is, and it's interesting how human nature adapted. So I mean, we had 70-year-old senior counsel appearing on Zoom, and doing well in the pandemic. So there's no cause to say it won't happen or cannot happen, and a hybrid system takes care of that. And if you see that again goes back to our favorite topic of access to justice, because you don't have to then run in and do it. And if you see, the maximum number of appeals to the Supreme Court are from Delhi, simply because it's 2 kilometers from the Delhi High Court, or less than that, right? And the number of appeals from south of India are lesser, because the geographical distance is that much farther. You need to get another lawyer there and the same person. Whereas if it was e-filing, if I'm arguing the same matter before the Bangalore courts, then arguably I can just do the same thing before the Supreme Court, appear online. You don't want to go find somebody else in Delhi, all of that. So there is an access to justice point, and there's no argument why it can't be done. And I'm all for simplifying. We just finished our annual appraisals, and every young lawyer in the disputes team is always complaining about how they can't deal with the registry and how that's the most mundane task. And no amount of law school teaching is making them ready for it. They think they're going to change the world, and most of the time they're standing with the registry officers. They're trying to convince them this is actually, please list the matter because there's urgency and not about objections. So yes, the only other point that I wanted to make to even to Navneet's question earlier was that unfortunately our judges are not trained to be managers of the legal system. There are people like you and I who are trained to be lawyers. So if you look at the budgets that's allotted to each high court, a lot of that is unused simply because they don't know what to do with the money. Every sort of technological step forward has to be because somebody else has to tell them about it. And then they're caught in the whole tender procurement system. They don't have the knowledge. So somehow we have to break this sort of conundrum of who's going to help them manage the whole legal system? How do they evolve? Because most of the day goes in judging, then they go back home and then they have to read the next day's cases. So they just don't have the mind space or the training to figure out how can we better the registry, how can we better the system, what way can we move forward. So we really have to have some way we can task somebody to make that sort of move forward, or whether it's the central government, state government, judicial academies, so that there is active ongoing movement on these issues. I do hear that the judges are quite overwhelmed and unequipped to deal with these situations.
You're so right there. If I may just add on to what Purnima said, Navneet, with your permission. I had written a column during the pandemic about the need for a list for mentioning, for orderly mentioning, because mentioning during the pandemic, during online hearing, was chaotic. Several people talking over each other just to get the first 2-3 minutes where you can just push in your case. So I suggested we have a list where you send an email to the registry, let's say by 9 o'clock that morning. So, and that's closed by about 10 o'clock, half an hour before it starts. So in that 1 hour, that half an hour remaining, that buffer time, the registry can come up with a quick list online for those who want to make a mentioning of cases. And I sent this column to one of the senior most judges in the Madras High Court, and he felt it was a good suggestion, and they actually started implementing this in some courts for a while. The other thing is for, examiners in sections to actually call to give guest lectures in law schools, about filing, because I think that's most important, more than your CPC and CRPC provisions. It's the actual nitty-gritty of filing and putting something together, of stitching a paper book, so that you don't really have compliances and matters are not bounced back for compliance and therefore further delay things. So these are two suggestions that I have, taking off from what you said, Purnima.
Thank you, Sanjay and Purnima. Navneet had to leave. So any other questions from anybody else? I see Dorothy is here. I don't know if she is still here, if she has some views on all this. Anybody else? Any questions?
I have a question, Ganesh. I'd like to hear from you. See,
Yeah.
Justice Sanjay Kishan Kaul had recently mooted the idea of having a buzzer. Like in the US Supreme Court, you have a 15-minute time cap.
Yeah.
So like a kind of a buzzer for lawyers to argue. Because some lawyers will say, how long will you take? I'll take the whole day. I mean, taking the whole day is grave injustice to the others who have matters. So why can't you summarize, George Bernard Shaw once wrote a letter to his friend saying, I'm writing a long letter to you because I don't have the time to write a short one. The more senior you are, the greater should be your ability to be able to summarize your stuff in a concise manner. 15 minutes, half an hour, 1 hour for submissions in a case should do. Don't you believe that we need to have a buzzer in court so that, we know that by the end of the day, so many cases can be adjudicated.
Yes. I completely agree, Sanjay. This is in fact in practice in many countries. In fact, in Singapore, if you go to the Court of Appeal, they give you like 2 hours for the maximum for both sides put together, depending upon, of course, the complexity of the case. I think we should implement that here as well. I can understand if it is in lower courts when you're having a trial, even that you need to restrict it to a number of days. You can't keep on cross-examining a witness. In fact, in arbitrations, we do it all the time. I mean, we say, this is what is the time allocated to you. You need to complete your cross-examination within a few days. I'm sure Purnima has got enough experience, much experience on this, both as counsel and arbitrator as well. We do that, we implement it meticulously. But I guess this will definitely happen if, for example, I mean, I don't know whether a buzzer will work because, you know, if, I'm not sure how that, I think the judge or the arbitrator has to be the buzzer. They need to say, this is it. You know, this is the time. And very importantly, you raised a very good point about submissions. In fact, written submission these days, even in court proceedings and arbitration, when you're giving written submissions, they need to just restrict it to about 10 to 15 pages.
Yes.
Otherwise, you know, you can put your case laws and other thing in a different bundle, for example. You can make references, but it should be concise. You don't want to keep on repeating what you said. I think that's not a very good thing. And that's why we were taught précis writing in school, you know. So if you can't summarize and get the crux of the matter and put it before the judge, it's also difficult for the person deciding if you have a 200-page thesis on your case, where exactly is the point? And I think that should also be in the awards and the decisions we make, because sometimes awards, they repeat everything, you know. So I think this is some kind of a training, which I think is improving a lot, Sanjay, I think. Definitely. I think it'll take a while, but we are getting there. Thank you so much. I think with that, we should perhaps close because it's close to 1. And unless there's any other questions from the audience, because it was supposed to be till 12:30, 12:40, we are at 12:50.
Navneet can email some of the cake, his birthday cake, his son's birthday cake to us.
Yes, to us. That's right. That's right. So Madhura, I leave it in your good hands to bring the webinar to a close.
Certainly, certainly. A big thank you to all our speakers, and we totally appreciate all of you sparing your Saturday mornings for us at ILA. And also thanking all the participants today who joined us. So we have this very interesting mentoring and guidance forum at ILA, and I'll take the liberty on behalf of all our speakers. If any of the participants wish to discuss anything with the speakers, they can just write to us, and we'll be happy to moderate the questions and whatever thing you want to share with the speakers. We'll be very happy to work with the speakers on that. So a big thank you once again to all of you. Have a great weekend. All our upcoming events will be updated on the website and also ILA social media. Please stay tuned and take care. Goodbye.
Thank you.
Thank
Thank you to all the participants and to the several thousand watching it on Facebook. We hope. Thanks so much. Bye.
Thank you, Ganesh. Thank
Yes,
you.
thank you.